Okay, Ms. Grubb, you there? Okay.
Sorry, Your Honor.
First things first, I know we have some subjects we need to talk about. Anything for the record so far?
I don't believe so, Your Honor.
Ms. Menashe?
No, no.
Okay, Mr. Zion, it's my understanding you wanted to discuss the subject matter?
Yes, Your Honor. It was my understanding at the sidebar that the court determined that it would be inappropriate for us to try to adduce evidence as to the defendant's state of mind regarding recklessness. Just referring back to, we did solicit that information on the record from Dr. Ely. We believe that this is an appropriate subject for to be explored upon, not with fact witnesses, but with Dr. Ely and with our other expert witness, now Dr. Schweiger. The court did have a motion in limine ahead of time stating that whether or not an instruction on reckless would depend on facts adduced at trial. This is the witness to do it with. This is one of two witnesses we intend to do it with at trial. So we would request the opportunity to ask this witness those questions, if not a purposeful act on part of the defendant. Is it at least reckless in your opinion? So that's why we're asking, that's why we would ask the commission to do that with this witness, at this time.
But he's testified that it's always been a purposeful act.
Correct, Your Honor. And so we would ask that, that reckless being a lesser mens rea on purpose, would this at least be a reckless act? So we would ask that that be allowed to be asked.
But if all the evidence is shown purposely,
Yes, sir.
why do you even give a lesser, since you basically are directed at that? That's how he was indicted. There's no reason to even address it because technically you don't even get the lesser.
Well, I think we get any lessers that are part of the greater offense if there's evidence of it at a trial. And so I think it is a reasonable thing to ask a witness, an expert witness in this case, who's you've given permission and find it appropriate to opine on a person's mens rea, if this is not, in your opinion, a purposeful act, a specific intention to cause their death, would you say that it at least is a reckless act? So, which is a lesser mens rea, and reckless is a lesser of purposeful homicide. We never indict lessers, unless it is the charged offense, and so we did not in this case, Your Honor. But we believe it is an appropriate lesser to instruct should evidence be adduced at trial. This is the witness, along with Dr. Ely, who's already testified, who did testify that in his opinion, if it wasn't purposeful, it was at least reckless. And that's all we're asking for.
Response?
Your Honor, it's my understanding, having read the reports, that this expert is going to say that with a reasonable degree of medical certainty and in his expert opinion that the intentions of Dr. Husel were to hasten the death. So the question of, in the alternative, if you don't think it was purposeful, do you think it was reckless, is an irrelevant question, and I would object to it, because the testimony is he believes that the intent is purpose, to hasten. He said that today, as with respect to all 5 patients that we've gone through so far, and he says that in every one of his 14 reports. So we don't get to the reckless or the questioning of, but for purpose, do you find reckless?
Any comment on the trial court's obligation in giving a lesser?
Yes, Your Honor. I think this case has been pending for 3+ years. I don't have the exact math. I do not believe that the law is that the court must give a lesser if a lesser exists under the Ohio Revised Code. I think if it is certainly, first of all, it's up to the judge to determine whether the evidence supports it. But it's not, we're afraid that we're going to lose as we've indicted, and so now we get a lesser. They've presented evidence and indicted a case on purpose with having to prove causation as well. That's the case that we've prepped. That's the case that we've readied for. And as this court knows, and we've certainly litigated this issue, it wasn't until this newer set of prosecutors were on the case that we even received an email about their intention to ask for a lesser. Truly, that had never been discussed in the 2+ years. Because had it been, we would have litigated the issue of immunity earlier. Also, Judge, you know best. You've been in this county for a very long time, and I've certainly done a lot of cases here. To say that this county does not indict on lessers is an inaccurate statement. They've had all this time to amend the indictment.
Okay.
We present it to a grand
Anything
jury.
else?
Judge, I've been here 24 years. Now, I know that is about probably half of what you've done, but we don't indict lessers. So I've done this job for 24 years. And with Jimmy and Ron, I did it for 23 of those years. So I am very much aware of how we indict. Any party can request a lesser if there's evidence of it. We're just asking for the opportunity to solicit that evidence from this witness, as we did with Dr. Ely, which is appropriate. The only reason we even talked about that lesser ahead of time was I was shocked by Ms. Menashe's assertion during a conversation we had, the one and only pretrial conversation we had about this in the summer, was that it was her assertion that because of the immunity statute, we would be barred from asking for any lessers, including reckless. She said, I understand that, but it's just the way the law is. And I was dumbfounded by her assertion during that conversation that there are no lessers in this case. I researched it, I had appeals research it, and they said, we don't know why you would not get a lesser in this case. And so I brought it up in the email ahead of time. Normally we don't discuss lessers until the close of evidence. And once again, it's both sides can ask. It's not like a defense thing. It's prosecutors can ask for lessers too, should the evidence warranted. So I brought it up in an email because I thought it might be germane to voir dire and perhaps even opening. And so that's the only reason I brought it to the court's attention. So that's where we're at on it, Judge. We're at that point where we are asking permission to ask what we believe is a very relevant question, the defendant's state of mind. It'd be the lesser state of mind. If it's not purposeful, is it at least reckless? Which I think is a perfectly acceptable question to ask this expert, as we did with Dr. Ely, who answered in the affirmative. Thank you.
Okay, well, just for the record, the simple asking still does not stop the court from going through the analysis they have to do.
Absolutely.
In order to put it there.
Right.
And the things I have, and that's what I'm basing my decision so far. I don't think it's relevant to this. I think everything is for the murder, and that's where we're at. So you made your record. We can go accordingly. The second issue, and I didn't really get a thing because we were kind of rushed, was about the leading questions. State of Ohio versus, and I'll spell it for you, D. Ambrosio, D''Ambrosio. Okay, 67, Ohio State 3rd, 185. Most of the questions haven't been leading. Even though they listed a yes or no answer, it doesn't necessarily meet the suggestion aspect required there. I had opted for part of 611 C is that except as may be necessary to develop testimony, that's the usual transition between subject matters, summation, those types of things that are traditional things. I may have said transition. Most of the time they weren't leading questions, but I figured it was better for me to say I'll permit it transition so I didn't look like one side or the other was wasting objections. But that was the whole thing. We can go through the analysis as we go, but just a simple yes or no question does not make it leading. It has to be suggested into the answer. And saying, did you review the records? Yes. That is not a leading question. So I made my record there. Anything on the issue?
Not from the state. Thank you, Your Honor.
No, Your Honor.
Okay. Anything else for the good of the order?
No, Your Honor. Thank you.
Okay. We're on recess till 1:05.